Hey, good evening. Thank you very much for joining us this evening for this important program. It is the second in our series, Shelter in Place 2, Protection in Place. I am Rachel Marks. I am associated with the law firm of Schonfeld and Goldring, and I'm also the Vice President of Shalom Task Force. And it is Shalom Task Force that brings us tonight's evenings, together with some wonderful co-sponsors: Achieve Behavioral Health, Ad, Amudim, Extended Family, Mask, Med Council, ORA, OU, Project Sarah, Sister to Sister, and United Task Force. Tonight, as always, we appreciate your co-sponsorship and working together. We last came together on April 1st, which at this point seems like a lifetime ago, almost 7 weeks ago. People were first settling into their homes. New York was on pause for just a few weeks at that point. And Erin and I did a webinar to discuss the status of the court system at that point, answer some questions, and update all of you on what was going on, where we saw things going a little bit, and to try and get our feet wet and navigate what was ahead. 7 weeks later, fast forward, quite a bit has changed. As it continues to do nearly every day. At that point, the court system was not yet open, with limited exception, and we've come a far way since then. Shalom Task Force in that time also has been very, very busy. We have moved our high school, Israel seminaries, and dating programs onto Zoom platforms, and over a dozen education presenters have been providing workshops to hundreds of students during this time. To request a workshop for your school or community, please visit our website and reach out to Avital Levin, who is our education director, and she can help you set that up. Our professional staff has also led several high-impact trainings for Jewish communal leaders, mental health professionals, first responders, and school-based professionals. We've reached victims and survivors through several community outreach efforts, podcasts, and interviews, to ensure that those who are experiencing an increase in violence can learn about resources and support. A lot of the resources and presentations that have been given are available on our website, so please visit shalomtaskforce.org. We have a special COVID resource page, and that might be helpful to you. Our hotline has been actively responding to an increase in calls and leveraging extensive efforts to support victims. So there's really been a lot going on during this time within the agency to offer as much support as we can during these very challenging times. With me tonight, once again, is Erin Bistricer, who joined Sarah's Voice in 2012, and she is the senior staff attorney at Sarah's Voice. Sarah's Voice is the legal services branch of Shalom Task Force. Throughout her career at Sarah's Voice, Erin has litigated numerous complex family law matters in both family and Supreme Court. Erin works exclusively with low-income domestic abuse survivors and provides services with respect and empathy to the particular challenges that they face. Erin has been supporting and holistically advising current and former clients on a host of issues unique to the outbreak, such as custody, visitation, unemployment benefits, mortgage, housing, and student loan payments. Thank you for joining me tonight, Erin.
Thanks, Rachel. It's nice to be with you again today. And thanks again to all those who are listening. Like Rachel said, this is going to be recorded and up on our website. So if you can't watch the full thing tonight, you can watch it in bits on our website. And if you are watching and you're not the survivor, I hope that this information that we contain can be of use to a friend or a relative of yours. We really put this together by the calls that my project was getting. We were concerned that people still didn't know that they could file for an order of protection and didn't know what a safety plan was. So those are the kinds of things we're going to go through later today. I'm hoping, again, just to spread the word that there are sources of help to those who are sheltering in place with their abuser.
Thank you. And thank you, Erin. I really have to give you a shout out and a note of appreciation for all the work that you've been doing with the survivors and victims, current clients and past, who are calling in and reaching out for help during these times. I also want to recognize that Shalom Task Force is proud to announce that our Executive Director, Dr. Shauna Friedman, has been appointed to the Mayor's Office to End Domestic and Gender-Based Violence COVID-19 Response Group. So it's exciting that our agency is present in these important groups, that we're able to offer our expertise and our guidance to the city of New York. So that's really exciting for Shauna, and she will, I look forward to hearing updates on that as our city moves forward through this time. Okay, I'd like to, Erin and I are going to jump right into it. I would like to just point out, just as we did last time, we have listeners and people joining us on this webinar from across the country. It's important to note that when we are discussing the law, we are discussing the law in New York State. Okay, so it's very important to make sure that you receive legal guidance and advice in your jurisdiction. Even within New York State, all jurisdictions are not uniform. Okay, when I say by jurisdiction is New York City versus Nassau County versus Suffolk County versus Monroe County. Those are different jurisdictions, different areas where people live and where different court systems function. So for the purpose of this webinar, we will be discussing New York State, and we will go into some detail about different jurisdictions such as New York City and Nassau County as we go through the evening. Okay, so as I said just a few moments ago, we've seen a lot of change in the past 7 weeks. We went from a court system that was essentially closed and open for very little emergency business only, such as orders of protection. And now 7 weeks later, when we've gotten our feet wet and people and the judiciary has had to adapt, we're at a place where there's a lot more business going on, a lot more court interaction going on. Erin, can you tell us a little bit about where we are now? Give us an update. What's the court system up to?
Okay, so the court system has been very busy since we last did a webinar. And Rachel, as you said earlier, this is very jurisdiction specific. My project can advise on the law in all of New York State. In terms of the nuts and bolts and filing, we have a lot more experience in New York City. But if you're outside of New York City, please don't be discouraged in calling us, because we can easily, if we don't know the answer on top of our head, find out the information for you. So in terms of what the courts have been doing, they've really been opening up. So let me first start with if you want to start a new case, because I think unfortunately this is still one of the areas that is somewhat limited. They still are not accepting new filings to start a new case for divorces, custody or visitation, or support. There could be exceptions to this, and I know that Rachel actually had an exception for this in Nassau County, but I would say for a rule of thumb, if you're trying to start a divorce case, if you're trying to start a custody case, or a new case seeking support for yourself or your child, that's still going to be a challenge to do. There are strategies that we have been discussing in terms of what's called preserving a filing date, which is the date that you would have started a new case, could you have done so? And filing dates are important because for instances like in child support, you're only entitled to support from the day that you file. And right now, since you can't file, that might be unfair. So what we've been discussing and advising people to do is that if they wanted to file a support petition, or if let's say they wanted to start a divorce, is to put the papers together as if you would have filed them, serve them on the other side, and if possible, we can talk more about this later, email a copy to the court. So when the courts open up access to the new cases, you could prove to the court, I would have filed on such and such date, could I have? And then request from the court that they backdate your petition or your summons to the day that, let's say, you gave notice to the other side, or the day that you emailed the court about it. We've heard from several sources that this is something that people are advising widespread, and that judges are going to be discussing this and considering it. So it's definitely something that I don't think is useless to do. I think this might be what the courts are going to have to look at going forward when they open up again. You can still file for orders of protection as before, and we're going to talk a lot more about that in the second half of this webinar. But in terms of support, so this can be a big issue, is that if you can't file a new support case and you separate, or you're already separated, how do you get that source of support? So there's two provisions in the Family Court Act that actually do allow a litigant, when they're filing for an order of protection, to also ask for an order of support. This is not something that was greatly utilized, at least by me before, because we would file a child support or a spousal support petition pretty quickly. But now that that is not a mechanism that you can do, we are encouraging litigants to ask for support as part of their order of protection. It is certainly allowed in the Family Court Act. The judges might not be super familiar with it, but I think if you come prepared and explain this is something that actually they are allowed to do, judges might be a lot more receptive to this argument rather than saying, just go file your support petition. And let me just very quickly highlight what those provisions are. There is Section 828, Part 4 of the Family Court Act, which says that a temporary child support order can be granted based on the children's needs, which is actually very important, even if financial information and assets are not available, and even if you don't have an emergency. And the reason that is so remarkable is that in a lot of support cases, they base it on the other side's income. And in a lot of times in domestic abuse cases, you don't know the other side's income. So in this case, it's actually saying it could be based on the children's needs, which means if you come to court with monthly expenses or weekly expenses of how much it takes to support your children, you don't even need the financial information about what the non-custodial parent is earning, though it could be helpful to have, which I'll discuss, but you don't need it. With regards to spousal support, which is support for yourself, the Family Court Act, Section 828, Part 5, says the court can direct the parties to appear within 7 days, business days, of the issuance of the order of protection, but in this case, you should need information about income and assets. Now, again, even though you don't need that information for child support, it still would be very helpful for a judge if you do have it with you, because judges, they don't really like needs-based hearings. They like something like tax returns or pay stubs. Now, I know in domestic abuse situations where a lot of people work off the books, that might not reflect the full amount of income, but the judge might still want to see that information and appreciate having it. So I would say if you're planning on asking for support, which we do encourage, even if you get some pushback, is to come prepared with all that information and make it as easy for the judge as possible. Because again, they might not be super comfortable ordering orders of support on an order of protection petition, but they absolutely can.
Erin, if I can interrupt
Yeah.
you for a moment there. Erin's given us some very useful information here, and I'm going to ask her to please repeat the sections of the law that you would bring with you to court. This is important because judges are not very familiar with this section of the law and their power to use it. It's not something that's generally invoked, but it can be. So if you come armed with this information and you give this information of the law to the judge, that could be very powerful and helpful to you. So Erin, please just repeat those sections of the law, and then I'd like to discuss a little bit more about what might be helpful in that situation and what you can bring to court.
So yes, Rachel. So again, for child support for your children, it is Section 828, Part 4 of the Family Court Act. And for spousal support for yourself, it is Section 828, Part 5 of the Family Court Act.
Thank you. And what's important to know here is that when you're going to court, okay, in this scenario here, you're going to ask for an order of protection in family court, and at the same time, you're going to be asking for this monetary support. This is the first time that you're appearing before a judge, okay, virtually or by phone call, but this is the first time you're appearing. This judge doesn't know you. This judge knows nothing about your situation, your children, your family, your spouse. So it's very important to come with as much information as you can. So even though these sections of the law give the judge the power to order financial support without supporting documentation, I would urge you to bring whatever documentation you have. Now, I know that often people may not have access to their finances. They may not have access to their credit card reports or their bank records, and really not have a good handle on their finances at all, even if they've been married many, many years. But bring what you can. If you can get your hands on a tax return, great. If you get on more than one tax return, even better. If you can make a list of your lifestyle expenses, things that Erin mentioned this, what do you spend weekly? What do you spend monthly? And do that, make a list of those things so that the judge can do a quick kind of lifestyle analysis of what's spent in this marriage. Okay, what kinds of money would be needed to support the children during this time. And that's important for both the child support, when you're asking for child support, and when you're asking for maintenance as well. When you're asking for maintenance, which is spousal support, you certainly need more information about income and assets. So bring as much as you can and try and prepare it beforehand. Okay, I've said this before, document. The more you bring with you, the better. The more information you have for your order of protection, which we'll discuss later on, the better. The more financial information you bring with you, the better. It gives the judge more ground to stand on so that he and she can make a ruling that they feel good about, that they feel is supported by the documentation. So if you provide them with the documentation and you provide them with these sections of the law, you're giving them a leg to stand on. And that's really, really powerful. So that's very important.
And I'll just add, when we say bring, so these are actually, they're virtual appearances. So you're not physically going in person. When we say bring, have it with you for when you do this virtual appearance, which we'll talk more about. I don't know if the judge is going to ask that you hold up the document so they can read the screen, but maybe the judge, just knowing that you have the documentation next to you, will feel like the judge feels like you're prepared. And, because these are virtual appearances being assigned to select judges, these might not be judges that really have a lot of experience doing support orders. They might feel uncomfortable about it. So if the request is denied, that is not, I don't want you to feel like that's a setback for you. You did something wrong. This is something that's, like I said, it's always under normal circumstances, something that's not always commonly asked for. But even in these circumstances, the judges that are taking these cases might not have support experience. But, the judges are aware that support petitions cannot be filed right now. And this might be actually an opportunity, because there's sensitivity to that issue, that the judges, if they're aware that they have this authority, might be more willing to help out on this.
Absolutely. Okay, that's really important and helpful for people who are going to be seeking that out. I just want to go backwards a little bit over some of the points that you made regarding new cases and how the court system is functioning right now. As you said, in most cases, the majority of cases, you cannot file for a new divorce now. So everything that you might be reading in the news about divorce rates skyrocketing and everybody's running to court, it's not true. It's fake news. Only time will tell what happens once the courts really fully open and COVID is a little bit in the rearview mirror, but right now it's not happening because it simply can't. You cannot file for divorce right now. Now, there are some exceptions to that, and those are emergency situations. But even in those emergency situations, you can't just simply file. You have to ask permission to do so. So as Erin mentioned, I've been over the past, I would say the courts opened up virtually probably about 3 weeks ago, or about 2.5 weeks ago. In Nassau County, immediately when the court started to open, I was doing several appearances, and since that time I've been to court virtually, to court appearances in both Nassau County and in Brooklyn. And in Nassau County, I was involved in a case. It was actually a domestic violence case where there was a criminal order of protection. The abusive spouse, or allegedly abusive spouse, was arrested. And because of that, there was an order of protection in place barring him from contacting or seeing his wife and his children. And he could not have parenting time with his children without an order from the court. So to get an order from the court, he petitioned to be able to commence a divorce proceeding, so file for divorce, so that we can get before a judge. And so a special form has to be filled out. That process, you go through that process, and then you go before a judge virtually. And the judge first had to grant permission for the case to begin, for the divorce to be commenced. And after that, then we had to deal with these issues, emergency issues of custody. And through several appearances between myself, opposing counsel, and the court, the judge the judge and the law secretary, that's an attorney that works for the judge, we were able to work through these issues. So there are cases where there's, unique situations, emergency situations where cases can be commenced. And it's also possible that those situations may be financial. Maybe there's a spouse who, or there's a concern that there's a spouse who may be depleting assets, or, playing games with assets, or mortgages, forbearances, things, the issues that are coming up these days. And in normal times, pre-COVID, what we do to stop the clock, as Erin said, is we file a summons for divorce, to commence a divorce action. And it basically stops the clock, and then it puts certain automatic orders in place that don't allow people to make these major financial decisions without consent of the other or the court. So now that we can't do that, because you can't be filing divorce cases, it's a problem. So in emergency situations, you can go to the court, seek advice of counsel, ask for permission to go to the court, and try and commence an action. Erin also gave some great suggestions regarding sending a letter, perhaps serving a summons without filing it, different things to preserve a date, all wonderful. Another thing that I suggest is not every divorce situation is going to be contentious. And it is an option to discuss with your partner or with your opposing counsel whether you can come to a stipulation as to a date of commencement. So yes. Put that in writing. What date are we commencing this divorce? Come to terms where you're both agreeing to put automatic orders in place. That way everybody feels a little bit more comfortable, and then you can move on through your negotiation stages to try and settle if that's the direction the case is taking. Another thing I wanted to just throw in there, that while the courts are opening more now, but are still limited, there's a lot that can be done during this time. Judges are doing a lot of work on trying to settle cases that were already on their dockets. So motions that were already submitted are being decided. Outside of court, lawyers are speaking to each other and trying to settle cases to get work done in that way. And the courts are also starting to pick up other non-emergency type of business. Yeah. So Erin, why don't you tell us a little bit more about pending cases?
So pending cases, I think a lot more can be done, as Rachel said. So in terms of conferences, which is when the judge speaks to either the litigants and their attorneys, but now it's mostly just the attorneys, the courts are actively reaching out to attorneys to pick dates where we can talk on the phone and just check in and see what's going on. But you can also, if you're represented, if you're having a problem on your case, and we spent a lot of time on our last webinar talking about custody and visitation. If you're having an issue, you can actually say to your lawyer, I think we should, or the lawyer might suggest that let's have the judge weigh in on this. So we can actually reach out now to a judge and request that conference. The ways to do that are very specific to each judge in each county. If you're self-represented and you don't have a lawyer, I would suggest that you speak with a legal office, and they can help guide you through how to properly communicate with the court and request a conference.
This is definitely a time where it's easier to be represented than be pro se. Absolutely. Pro se is when you're representing yourself. It's a little tougher since there's so much direct contact with the court during this time.
But it's still an avenue that's available. So like, yes. Even though we don't want to discourage you because you're self-represented from feeling like you can approach the court. You could, but we would recommend that you speak with the lawyer about how to maybe phrase the communication and how to reach out. So again, both in family and Supreme Court, the courts are reaching out to do conferences. And what you can do right now is that you can actually file motions on your case or response papers if a motion was already served on your case, which wasn't happening until a couple of weeks ago. So I'm going to share a slide just so you can get a sense of what that looks like. This is the form in New York City. This is the website. Again, this is going on our website that you go to file a motion with the court, a motion seeking some kind of relief that you put in writing. And the judges are now getting those motions, giving the time for the other side to respond, and sometimes are making a decision without you having to even conference the case. They can do it all just based on papers. So this is, again, very helpful for people who have cases already in court to get some help from the court. And this is a sense of what the form looks like. But again, if you need help filling out these papers, if you don't have a lawyer, call my office or another legal service and get advice on how to fill out these papers. And our information here, and we're going to post this later on, is posted over here. We're accepting through call and text and email right now inquiries. And you can also reach out to the Family Justice Centers if you need to. And I just want to make a quick mention of support. So, the courts are not accepting new support cases, but they are accepting modification cases, which is something that's actually happening right now in real time. They're rolling it out at the end of this week or early next week. So this is something pretty new in New York City. I think Nassau County's had it for a bit. So if you already have a court order, my understanding is that even if you don't have a case actually pending in court, but you have a court order, you can now file, and we're going to post information a little later, you can actually file for a modification of that order if you're the custodial or the non-custodial parent and there's been a change in your circumstance or you're impacted by COVID, you can now go to court and seek to change that order.
In Nassau County, it's a little different. We don't have the same unified email address that you're going to be providing there, and you still have to seek permission to bring a non-active case in. But if there is if there is a pending case right now, you can reach out to your judge, to the law secretary, to ask permission to either file something or to ask for a conference to try and discuss it. It's very important to try and resolve issues. The judges have stressed this, try and resolve any issues before filing a motion. You should be making a good faith effort with the other side, schedule a call with the court to ask for guidance, and if all else fails, then file a motion.
Sure.
What's also important to point out is that it's important to continue your obligations as per your agreements. So whether they're temporary agreements or you already have either a disposition from the court, a decision from the court, or some kind of global settlement agreement, you're already divorced, it's very important to follow the orders and follow your agreements, both when it comes to parenting time and custody and your financial obligations. So the court is, of course, going to listen to any new circumstances and look at that evidence and all of that. But until a new decision is made, everyone is expected to be doing what they can to follow the orders that are in place.
And I would say, the main difference between custody and visitation now than what it was when we did this webinar back in April is that we don't have to necessarily guess anymore what a judge would do in this situation where there's so much anxiety of my ex-partner wants the visitation or is not exercising visitation. What do I do? So again, it's still not clear cut. Every situation is very different, and there might be cases where the order no longer makes sense and might be potentially dangerous. But now that you have access to the jurist, or supposed to have access to the jurist, at least try to do the steps of reaching out to your judge, either yourself or through the lawyer if you're represented. So at least then, if you make those efforts, you can potentially get the judge to weigh in, and that would give a lot more clarity and hopefully lead to less anxiety if you're able to get some clarity on what should be happening with the visitation schedule right now. First, try to work it out, and if you can't, that is now an option available.
Absolutely. And what we're seeing and hearing from the judges over the last month or two is that people really are being encouraged to follow their parenting schedules as they existed previously, unless there's a specific health threat or reason not to. And in those cases right now, like Erin said, you are expected to then reach out to the judge who's involved if there is still a judge involved. And that's really important, where, the courts are saying as long as it's safe for children to be going back and forth, absent a specific threat or something like that, then they really should be doing so. Whereas again, back 7 weeks ago, we didn't know where these things were going to go. We were telling everybody to do the best they can, that the courts would look in the future what was being done during this time when they did open and all that. And now we have more guidance and we know what's been happening, and it shows us the path that we should be taking and how we should be advising people. Okay. Erin, any other words on pending cases?
I do not have anything further.
Okay.
So should we move on to safety planning?
Sure, but I want to remind
Yeah.
everybody that the slides that Erin is putting up on the screen are all available on our website at shalomtaskforce.org. I know that we're going through some of the information quickly and a lot of it is important. So just go over to our website and the phone numbers and websites, and that's all there for you. So that's up right up on our website. So don't worry about that if you miss it. Okay, so staying safe, Erin, what has been going on there? What have we been seeing through our hotline, through Sarah's voice? Are the numbers up? Are we seeing what, is it what we expected? Is it not what we expected? What's going on?
The numbers, we're still getting a healthy number of calls, but from what we've been hearing from other service providers is that overall across New York State, domestic abuse calls are down. And this is not giving anyone the feel that there is no domestic abuse going on right now. There's actually this eerie sense among providers right now that we're not reaching the people that we want to be able to be reaching, because the shelter in place policies will entail that people are home more with their abusers and have less opportunities to seek out help. That is why we think the numbers are down, or that people are so overwhelmed that they're not able to call because they have other life issues that are going on. So there's been a lot of calls. I just participated in one this morning with the mayor's office, but both the mayor's office and the governor's office has been very clear that they believe that domestic abuse is probably escalating right now, and that the decrease in numbers is not an indication that there is a decrease in this issue. So one thing that I want to share now and take the opportunity to share is, Sarah's Voice, my organization, we are expanding our intakes to receive also emails and text messages. So the numbers and the email is listed here. This will go to our, who I want to give a shout out to, our victim advocate, who did phenomenal work in putting these slides together, and also in managing our calls right now, is if you call or text this number, which is the number that we've always used and received calls at, or if you email this address, it'll go to our victim advocate who works business hours. So it's approximately 9 to 5, Monday through Friday. If you don't get a response right away, please don't worry. She will get to you, and she just might be on another call. So this is not intended to be an emergency line. So if there is an emergency, we do recommend that you call 911. But if you're trying to reach out and you're not able to get on the phone because you're living with your abuser and you don't want them to hear, we're hoping that this can really expand people's access to resources, because now you can call, now you can text and email. But I do want to take a moment to point out something at the bottom of the screen, the Tech Safety app. So when you're reaching out through tech, which can be really helpful in expanding your ability to get services, there could be heightened safety concerns that you should just be aware of. So, a very common form of abuse, which we can talk about a little later, is when someone takes your cell phone and monitors your calls or doesn't give you access to your cell phone. So if you're going to use tech to reach out, just be mindful of that and take precautions to try to prevent the abuser from realizing that you're reaching out. So that could mean saving this number under a different name in your phone. Deleting the message after you text, deleting that message or that conversation you have with us, password protecting your phone, checking your phone for any type of malware that allows someone to hack in and see what you're doing remotely. So this website that we posted at the bottom of the screen provides more information about that. And we just wanted to make you mindful that even though you might want to reach out in writing to us, just only do so if you believe that is safe in your circumstances.
Thank you, Erin. I'll leave that up there for a moment.
Oh, sorry. Okay.
I just want to reiterate some important things that you said, and may as well leave that on the screen. It's important information. When this all began, people were very concerned within the community, within the domestic violence community, that people are going to be stuck in their homes and quarantine with their abusers. And everyone was very worried about the increase in incidences, and we thought that it would then translate to an increase in calls and to reports. And as you said, what time has shown us, and we saw this pretty early on, that it wasn't translating to that. So we know that the people are in these situations. We know that the situations are escalating. because there's added stress, people are stuck together, there is less access to outside support systems, people are unable to get away for a short while, et cetera, et cetera. So we know that it's happening, but the calls are not reflecting that. And that's troublesome to us, and we're concerned for people because of that, because we know that it's happening, we know that it could be happening to you, we're here for you, we believe you, we feel for you, we want to help you. And stemming from that was this is this email address and this text line to give people another avenue to reach out, another way to reach out. It's not so easy to make a phone call when somebody is following you around the house or not allowing you to leave for a few minutes or monitoring everything that you say. And these are all things that happen pretty often in abusive situations. It's not something that's unheard of. So by Sarah's Voice providing this text line and this email address, we're giving people the opportunity to reach out in another way. So hopefully we can help them. So that's a wonderful addition. It's also important to know that the Shalom Task Force hotline, the hours for the hotline are extended longer than you had mentioned, that this will be answered during business hours. The hotline hours are longer than regular business hours, although legal advice is not offered on those calls, but we are there for other resources and a listening ear. So that's important to know. It's also important to know that there are other resources, which we'll get to later on, that do have text lines as well. Okay, so they can offer you that support. Okay. Let's go on. Okay, so what kinds of abuse? So we know that you're getting calls. They may not be the volume of what we expected, and that's across the state, actually across the country. Other agencies are experiencing the same thing. We're not getting the volume that we would have hoped for, so that we can reach all the people that are in these situations. But we know we're getting calls. What kinds of calls are coming? What kinds of situations?
So it is, we are seeing the kinds of abuse that existed pre-COVID, but now they seem to have a level of like additional twist to them. So one is that, for people who've separated, their abusers might not be able to have physical access to them anymore because of these shelter-in-place policies. So there is an increase in online harassment and stalking through social media or through other means. So that's one thing that we've been seeing, which is why tech safety is so important. Another thing is we're seeing this excessive control that they're using to justify in the realm of COVID, being like, I'm like this because of COVID. And they're using that as an excuse to excessively monitor. And some ways that we're seeing that is to say, you cannot even call your friends or your relatives, your friends or your family because it's too dangerous. You need to socially isolate, but they're taking that to an extreme degree by saying social isolation through phone calls even, which has no basis in science, but it's really a mechanism that people are using to further socially isolate someone. We're seeing control in terms of sanitation. So either forcing the victim to constantly having to wash their hands and use hand sanitizer, and in the reverse, not allowing them access to hand sanitizer or protective equipment, not allowing them any privacy in the home. So, kind of like stalking them through the home, following them room from room, seeing what they're doing, monitoring their calls, not giving them really much time to themselves, not allowing them to go for walks, go out to get errands, to run errands, get food for the family. We're seeing denial of access to health benefits, so not allowing them to see what the health insurance information is, not allowing them to go to the hospital for medical needs. We're hearing cases of increased substance abuse. So there is, this is not to make people scared, but this is just so people can be aware that, if this is happening, we've always talked about the term gaslighting, making that victim feel like everything is their fault. This is happening now also, saying things like, it's your fault that our family might have been exposed to COVID, even if they have not been exposed to COVID. And those tactics are still now being, like I said, used, but with an added twist. So we really want to emphasize that if these are things that you're experiencing or someone is experiencing, it's not your fault. It's just, unfortunately, abusers, they take advantage of situations and they really use it to their benefit to maintain that control.
So true. Really good point. So what can we offer these people who are reaching out? Can we do safety planning with them? What can we do?
Yeah, so safety planning is really crucial right now. And if you're not already aware of what the term safety planning means, it means it's a personalized, practical plan that includes ways to remain safe in your relationship, to create a plan for leaving that relationship if you're at that stage, or plans to keep you safe post-relationship. And this webinar is not intended to replace safety planning. It's, like I said, it's personalized. So if you have the opportunity, reach out to my project or other projects to do individualized safety planning. So you can come up with a plan that helps you keep safe in your individual circumstances. But I do want to go through some tips that could be helpful to think about in these situations. So let me just get to the next slide, which again is on our website. So one thing I really want to highlight is take time for your health and your well-being, which might not be conventionally thought about as being part of a safety plan, but I find even just in my personal life that if I'm too overwhelmed, I'm not going to be able to think and plan ahead. So this really just means things like basics. Make sure that you're eating, make sure that you're sleeping. I know that things could be very difficult right now, especially if you have children in the home or if you have an abuser who's not giving you time. But to the extent that you're able to carve out even just a short period of time for yourself to do something that you like, you know, read a book, have a hobby, or just breathe. There's a lot of apps right now online about meditation, which is really helpful. Just try to create some space for yourself and remember what your needs are. If you can, like, just even maybe if this is something you're able to do in your house, leave reminders around the house just to like take a drink of water or eat. Because I think just these little tips can help you go on to the next step, which is how to plan for your safety. So we already mentioned tech safety, but some other areas could be, you know, texting or emailing, which we talked about, not just to legal service providers, but to friends or family. Try to think of code words that you can use. So if I, let's say, text you this word, it means that I need help, call the police, or I need you to do this, or that means I'm leaving and I need to come to you, or I need you to file this order of protection that we worked on together on my behalf. So to the extent that's safe, do that, and maybe try to communicate with people while you know that your partner or ex-partner is busy. So if you know there's a time of day where they are sleeping or they're busy at work or they're doing something else, they're in the shower, maybe use that as the time where you can communicate. Also see if you can make it part of your routine to take some time out of the house. If you're allowed to go for a walk or if you're able to go get groceries, do reach out during that period of time. Avoid some rooms if possible. So for example, if the abuse is escalating and there might be rooms that have weapons in it. So for example, the kitchen, if possible, try to avoid those rooms when you have a sense that the abuse might escalate and go into a room that could be safer. So maybe a room with outdoor access that has a door in it. So if you needed to, you can leave. Another really big one is this one over here, the creating of the incident list. This is really important. We're going to talk about
document.
Yes, that's our code word. We're going to talk about the order of protection, but this is really important in helping create the order of protection. What we find is when we talk to callers is that they can't remember the incidents that impacted them and what happened, especially for things that didn't involve a direct physical contact. So if the incident wasn't directly physical, they have trouble remembering something, for example, of the nature when the abuser is throwing items or smashing items and generally acting in this intimidation behavior. So an incident list is a log or a journal. If you can create it safely, it's written where you write down or you text to a friend or a relative on this and this date, this and this happened, and explain with some level of detail as to what kind of behavior was the abuser showing that made you feel scared for your safety. It doesn't have to only include physical violence or sexual violence. It could include verbal, financial, and emotional abuse or any general conduct that made you feel frightened. And this can be really helpful in later on explaining to someone who's working with you or for your own knowledge as to why it was that you felt like you needed the order of protection. And then that way you'll have the incidents all written down and then the judge will understand why you're filing for this order of protection. Just a quick note on planning with children. So obviously this is very fact specific, very age appropriate. But if possible, like depending on the child's age, if you can create a signal for when you want the child to come to you, if you feel to protect the child, and if the child is old enough to teach the child how to call 911. And again, this is not to make you scared, but we find that if people plan ahead and have something in place, they feel more prepared to react to a confrontation because they know, okay, this is my plan, it's going to kick in, it's kind of instinctual. So just having these measures in place is not to necessarily scare you in the moment, it's to prepare you in the future.
Absolutely. Really important to be prepared and have that available to you so that you can, again, when we'll get to speaking about orders of protection in a few minutes, if that's on your path and something you're going to have to be working on, you're going to have all that information available to you and it'll make it all that easier.
Yeah, and again, these are resources for help in terms of safety planning. These are places that you can call to create that individualized plan. The ones that are in red are the ones that we're aware of that has the call or the text function. I just want to say National Domestic Violence Hotline is 24/7. And I also want to say Safe Horizon right now has virtual counseling. So you can get counseling over a remote device, so you don't have to go in person to see a therapist. And again, this is so important in creating that space that I was talking about and letting you kind of clear your mind, getting your mental health addressed as well as your physical health.
Absolutely. Very, very important. And so now what if somebody does decide that they want an order of protection? You've gone through, you've gone through the safety planning. We urge anybody who feels that they are in danger, or even if they aren't imminently, but to work, to contact somebody to help them work through a safety plan. But now what happens if somebody does decide that they need an order of protection for their own protection, maybe that of their children as well? What do they do?
So there's two ways to obtain an order of protection. The first one is through the criminal process, which essentially starts with someone calling 911, the police come, they arrest an abuser, and then they refer the case to the district attorney who refers the case to a judge. And the judge will arraign that person, charge them, and issue an order of protection to keep you safe. It can include your children, and that's just the general process, how that starts. The main thing to think about with the criminal process is that the case is being essentially run by the district attorney. So you don't have the control that you'll have in the family system, which we'll talk about, which is that if the district attorney decides to prosecute, that case can go forward whether or not you want it to go forward, actually. You're the witness in the case now, and even if you don't cooperate, if they have enough evidence to prosecute without you, they can prosecute. And on the flip side, they can also...
I might interrupt for a moment.
Yeah. Mm-hmm.
I just want to explain what that means by you're the witness. If, for example, if there's a divorce action, then you have one party against the other. So it's Jones versus Jones. When we're talking about a criminal action, it's the people of the state of New York versus Jones. So the person, the victim, is not the plaintiff as they would be in a civil matter. They are acting as a complaining witness in that case. So it is not, it's not in their control whether the state continues with their case against the defendant. While they certainly would be asked for their input and would be asked to participate, it is not their case, and they don't entirely hold, they don't hold the reins to it. Go on.
And this is not to discourage people from going through the criminal system. It's very individualized what your preference is. I have worked with a lot of people that prefer the criminal system because, it's kind of taken out of their hands in a sense. And they actually prefer that because a lot of the work is being done by the DA. They don't have to come to the court appearances unless there's a trial. And that is a lot less stressful in some sense than being responsible for starting the case yourself and then attending all the future court appearances. Another hesitation I have heard from...
We also don't have the burden of having legal fees of having to hire.
Yes, yeah, that's a really important point. Yeah,
that's a big point too, because when you're a party to a civil action, either you represent yourself or you hire a lawyer to represent you. In a criminal case, again, you're a witness. You're not bringing the case. So you don't have to have your own lawyer. Some people might like the advice of counsel, but you don't have to have your own lawyer.
Yeah, that's a really good point. And another concern that I have heard from people about the criminal system is, they're actually, this is very typical. They don't want their abuser to have a criminal record. They're saying like, I want safety, but I don't want to hurt them. So I think it's worth mentioning that, this doesn't happen in every case, but in many cases I've worked with, the case actually resolves without the abuser getting a conviction, or at least not one that's going to create a long-term record. A lot of cases can end eventually in dismissal. They take a plea bargain, especially if this is a first-time offense. But, you know, there are cases where conviction results. It really depends on the severity of the incident, but many cases do not. But you can still get that order of protection. They essentially work out a deal with the district attorney where the order of protection is issued for X amount of time, but the abuser will not have a criminal conviction. The case will ultimately be dismissed if they do not violate the order of protection. And this is really important for people who are worried about their abuser having a criminal record, if it's going to affect employment, which could then affect child support. So, you know, there could be,
It's
yeah.
really specific.
Yes.
And you couldn't, you know, nobody can guarantee what the outcome of that would be.
No, we couldn't promise it, but I would say
discourage somebody from calling 911
yes,
or for getting an order of protection. Absolutely not. But it's always better just to go in eyes wide open, know what the process is, and know what may happen.
exactly. Now, we've worked with people who have orders of protection both from the criminal side and the civil side, which is the family court route, or through a divorce. And people like to sometimes do this because, like I said, the criminal case can sometimes get dropped, and that's not your decision. So sometimes, even if you have that criminal order protection, you might want the family court order protection too as extra insurance. The standard of proof is lower in a family court proceeding because it's not a criminal proceeding. It does not result in a criminal conviction, even if an order of protection is issued. So, and you can do the family court system without having to go through the criminal court system. So even if you've never called the police before, you can still seek an order of protection in family court. So let's talk more about how to do that.
Erin, I also want to point out that whether you have an order of protection from family court or criminal court, if that order of protection is violated, you call the police all the same. There's no difference between the two, and the repercussions are the same. So one is not stronger than the other if you have one in place.
Yeah, I'm really happy that you pointed them out. They're both binding court orders, and they're both serious if there is a violation.
Right. Okay, so through it. How do we get one?
Okay, actually, let me take one more step back. I'm sorry. I know people want to get into the nuts and bolts of this. There are two kinds of orders of protection. I thought I should mention that. There's the stay away orders of protection, which says to an abuser, you cannot go near this person, contact them whatsoever. It could also include the children. And then there's the refrain from orders of protection, which says to someone, you know, refrain from certain kinds of behaviors like harassment or assault or stalking. Again, like I say, these are behaviors they shouldn't be doing anyways, but they need the court order to tell them that. And even though this is not the impact of a full stay away, it's still valuable to have, because if they violate that, that is a criminal offense. And sometimes getting this written down in paper might put the intimidation into the abuser to really be on their best behavior and not to mess with the system. It also shows to a court there is a history here, so people are aware. It might make the police take incidents in the future more seriously now that they know an order of protection has been issued.
Absolutely. When somebody has an order of protection and the police are called, what they're essentially saying is that a judge has already taken notice of this case and has found reason to put an order of protection into place. And so it just may make them take it more seriously. There would be an additional charge, presumably one for whatever the action is that you weren't supposed to be doing in the first place. And not refrain, and then one for violating the order of protection as well. But it just gives a little more gravity to the situation.
Yes, thank you. So this is the process that's, you know, pretty specific to the COVID landscape that we're in, though a lot of these principles are still the same from what they were before. So the first is filling out the petition and drafting it. This is where the incident list comes in. We recommend that if you have the leeway to either call our organization or to contact the Family Justice Center for help in drafting the petition. I just want to kind of show what a sample petition looks like. It's, you know, essentially it's a form that you fill out. You put down where you're living. If you're living at a confidential address, put that in. Where the abuser is living, what your relationship was to each other, whether or not you have children. For this one over here, number 3, we just recommend that you check off all the boxes. These are potential family offenses that the other side could potentially be found to have committed. And we just say, throw the kitchen sink in. It's not going to harm you later on. The rest of it indicates whether or not you've previously filed any police reports or criminal complaints. You put information about the children if applicable. And number 6 is really where the meat of the application is. This is where you're going to put down the incident list. You don't have to include every single incident, especially if you have a very long relationship, but the more that you can provide, the more information that the judge will have. I do want to note here that unfortunately judges seem to respond or understand physical or sexual abuse more easily than they do with verbal, emotional, and financial abuse. So if those are your primary forms of abuse in the relationship, it is possible that you will not get a full stay away order of protection. It really depends, I think, on the specifics of your case and how the petition is drafted. But we would say that if you are drafting this and there is physical abuse, lead with that because it's going to catch the judge's attention more easily. This is not to downplay the severity of the other forms of abuse, such as emotional, verbal, and financial. It's just the reality, unfortunately, is that the courts still struggle to really understand the impact that can have on someone. They don't necessarily mean that they can say it's horrible, but that doesn't mean you're unsafe, quote unquote. And even though we recognize that there are various forms of unsafety, when we're talking about the order of protection, they usually will not issue a stay away if that is the sole form of abuse. But like I said, it is very case specific and you should speak to an attorney about it. Another example, another good way to start off this petition is to really explain why it is that you're filing this now. What made you decide to take this step right now? Because usually that will help trigger a judge. Okay, what's the concern right now that you feel unsafe? And that will help the judge understand why it is that you think you need this order of protection.
Very important. So you want to put in as much history as you can. You want to begin with the physical instances, sexual instances. So give a nice round history of what's going on. But it's also very important, as you said, to answer the question, why now? What brings us to this point right now? What brings you before this judge now? Why now? Very important.
Mm-hmm. I also want to note that you don't need evidence at this point in the stage. You don't have to have a pile of text or recordings. You just need to put down the incidents in writing so the judge can understand what's happening, but you don't have to have the whole case thought out at this stage in time. This is really a mechanism to allow you to get into court and to get relief quickly. And the judges understand that you're not going to have all this documentation with you on the first court appearance. You should put in whether or not any orders of protection have in the past been violated, whether you think your abuser has access to firearms. This is really important for the court to be aware of that. If you're not sure, just put down you don't know. You should put in if there's any other, number 11, if there's any other cases that are pending in court right now. And in terms of signing, so the courts have really relaxed notarization requirements. There are ways to do it remotely, but if you can't, I think what's important is just to get this petition in, even if you can't notarize it. I would say, like, if you could sign it, but even if you can't do that, send it in, because I even heard today that they're not even requiring petitions. They're just requiring a request. I would still recommend the petition because I think it could be very judge specific, and the more information you provide, I think the best practice is to do the petition. Though I don't want to discourage people who don't necessarily have the capacity to print, sign, scan. I think what's important is to get this request in, and then issues such as signatures can be sorted out later.
Absolutely.
And again, if you can't maybe necessarily send it yourself, if you have some tech issues, try to get someone involved who can help you, whether or not that's a friend or an organization.
Very important. You're right. But we also during these times have to prioritize what needs to be done to get the job done. And so something like a notary is holding you back, don't worry about it. Get in what you can and we'll deal with it later. Okay, Erin, the hour is getting late, but there are some more important issues that we do have to go through. So I'd like to move on a little bit. We discussed calling the police, calling 911. There's a dangerous situation and what might result with an order of protection and how you would go down that avenue. But a lot of times people are very fearful of calling the police, particularly when they have children. They're worried about what's going to happen. What if my partner is arrested? Will ACS get involved? Children's Services? Will I be faulted in some way or looked upon negatively? Can you please tell us, speak to that a little bit? Is that a real concern for people and what should they do?
Yes, 2 seconds, because I know we are running out of time. I just want to emphasize here, this is a virtual appearance. You do not have to go in person. In fact, this whole thing is designed that you can email. You'll be put into a virtual courtroom. You'll be given a PIN to access it. So you do not have to go in front of a judge. So if that is a concern for people, yeah, for orders of protection, you are not going in person. In terms of, yes, Rachel, thank you for bringing up those other issues. So if you call the police, what should be happening and what we're hearing is still happening in COVID, though, you know, there might be exceptions where the police aren't coming because they're nervous about exposure, but police are still investigating. They're still showing up. They can make an arrest. And they don't make an arrest in all cases, but in all cases where you call the police, you should be able to fill out what's called a domestic incident report. If you have the flexibility, if you don't want to call the police, you just want to make the report, you can still go to precincts, they're still open. The domestic incident report is like a pink slip that you fill out to describe what happened during the incident. This can be a challenge for people, especially who have language barriers. English is not their first language. So we recommend, if possible, first of all, to request a translator or to write on the form that English was not your first language, and that could help explain later on why certain information was perhaps left out. Yeah. And I would say that if you are able to call ahead of time, if you're thinking there might be a time in your life where you might have to call the police and you're worried about how to talk to them, our organization can speak with you about how to advocate for yourself with the police. So that is still happening right now. And with regards to children's services, so the thing is that with the criminal system is that if the incidents involved danger to the children, where the abuse was directed at the children or abuse happened in front of the children, the police generally call children's services. That's what they're required to do. And children's services will investigate. They are still doing investigations right now. They are still doing even home visits, though it could be case by case, where if you say, I don't feel comfortable letting you in because of COVID, try to see if you can get some video so you can take them through a walkthrough, put them in touch with the children, maybe open the door so you can stand 6 feet apart and see each other face to face, but not in close proximity. So children's services are still investigating, but I think there's this common fear in our community that if children's services gets involved, that means the children are being taken away. And I really want to say that, again, this is very case specific, but in my experience, it is a really rare circumstance where children are removed from the home. And it generally only happens if the children's services believes that the children are in ongoing danger. There is a concept, it's a very well-established policy that children's services should not hold a survivor accountable for abuse that the children were exposed to during that relationship. So they should not be taking the kids away because abuse had happened in their presence. But they might say, if you're going to continue exposing the children to harm going forward, so for example, you say, I'm going to let the abuser back in the home when there's a criminal order of protection in place, that's where I think we hear the cases where ACS or CPS takes a much more aggressive approach. And even in those cases, it's, you know, sometimes it could be fast, but in a lot of cases, it's that maybe they'll start a case in court because they're concerned and they want to make sure that the custodial parent is getting access to services. Maybe they won't start a case. Maybe they'll just work and continue investigating the family and keeping the case open. So there's a lot of actions children's services can take. And the one of removing the children from the home is the most extreme one. And it's not one in my experience that I've encountered very frequently in this community. It's one, again, where I say that I hear those cases where Children's Services is getting the sense that the survivor is allowing the abuser back into the home without proper court supervision, like without an order of visitation, but there is an order of protection in place.
That's good to know. So it doesn't, you know, it's something that people should definitely think about, but not something that should weigh heavily on them in terms of having their children removed. If you are in danger, you should feel comfortable calling 911. And should ACS get involved, you will work with them and explain to them the circumstances, consult with an attorney if necessary, and hopefully you'll work through that process successfully. Okay, our time, it's late. Our time is, we're wrapping up here. I want to just address, I see some questions have come in. Most of them we've actually already covered. There are some very case specific ones. I urge you to please reach out to Sarah's Voice. All of the phone numbers and information will be available on our website. And it's coming somewhere.
Yeah, it's here. But actually, I just realized I skipped a slide earlier. This slide over here, this has the email address and the phone number. You can call the clerk if you're not able to email to access someone to speak to in the court system. And the second one on the bottom is what we're expecting in New York City to be the email address that you can use for filing a child support modification. So
Right.
again, this is all going to be on our website. If you're not able to take it down now, I think it's already up under our COVID resources. And this is, again, resources that you can use for safety planning.
So reach out to Sarah's Voice. We hope to provide the guidance that you need. There's another question here. The question is, can you please give an example of documentation? I guess somebody's listening to me saying document. Okay, so documentation, in terms of financial documentation, we're talking about tax returns, credit card statements, bank statements, utility bills, mortgage statements, rent checks, anything you can get your hands on. Really anything would be helpful. And in addition to that, or even without that documentation, if you can make a list off the top of your head of how much you spend on things, how much you spend on groceries, how much you spend on gas, approximately what your utilities, rent, or mortgages, things like that will give a rounded picture. That's what I mean by financial documentation. When it comes to instances of abuse, documentation can be this log that you're keeping of things that happened, different instances, whether they were verbal abuse, a specific financial instance that you can pinpoint, something physical, sexual, keep that all in your log. That's documentation. In addition to any police reports, doctor's reports, emergency room. If you ever, if you speak to friends about different things that happen, jot that down too. On, April 15th, I spoke to my friend Mary about what happened yesterday. That's really important in case one day we need to call Mary as a witness.
Yeah, very good point, Rachel.
So that's all, those are all kinds of documentation. And, there are all different kinds of various things that you could specifically discuss with an attorney and somebody who can advise you to the situation that you're in and the specific circumstances. Okay, so Erin, thank you very much for joining us.
Thank you, Rachel.
This was really informative. The system, what's going on in the courts is constantly changing. As we said, what we brought to you on April 1st is very different than what we discussed tonight. It's evolving, and I expect that it will really continue to do so over the next weeks and months until we go back to the pre-COVID days. So if necessary, we'll be back to discuss and to update you. In the meanwhile, stay safe, stay healthy, reach out, call our hotline, call Sarah's Voice, be in touch, and we hope to offer you the support that you need during these times. Have a good evening.
Have a good evening. Be well.